Hello and welcome everybody. Thank you for joining us today for today's training on national origin discrimination, workplace issues and civil rights protection for immigrants and refugee workers. This training is brought to you by Switchboard, a one-stop resource hub for refugee service providers in the United States. My name is Rishan Habte, and I'm the Program Manager for Economic Empowerment at Switchboard. I'd like to start by mentioning that today's training is going to be 75 minutes and it will be recorded. Tomorrow, you will receive an email with a link to the slides, resources, and a survey. So before we get started with the webinar, I just want to go over some basic Zoom etiquettes. I'm sure everybody's zoomed out, but we'll just go over a couple of things. Okay. So all attendees are currently muted because we have a large group today. You can unmute yourself, or you can turn your video off. Sorry, never mind. You'll all be muted today, and please keep your videos off. We welcome your comments and questions throughout today's session. Click the chat bubble icon in the bottom center of your screen to open chat and send your chat messages to everyone, so we will all be able to view your messages. You can also raise your hand. You have the option to raise your hand or use other reactions. Click participants, then click an icon to react. And today's agenda, by the end of this webinar, you'll be able to list types of discriminations that are covered by the law, identify workplace discrimination, describe how a client can file a charge if they feel they have been discriminated against, describe the difference between the Equal Employment Opportunity Commission, EEOC, and the U.S. Department of Civil Rights Division, Immigrant and Employee Rights section, IER. Okay, so let me start today by introducing our two speakers. We have Liza Zamd, and she is a senior trial attorney at the Department of Justice, DOJ, Immigrant and Employee Rights section. And we have Maria Flores, and she is the outreach and training manager at the U.S. Equal Employment Opportunity Commission. So with that, I will hand it over to Liza.
Great, thank you so much. Thank you for Switchboard for creating this presentation today. And I was looking through the participants, and I know some of us already know each other, but hopefully today you'll be able to get some information that you didn't know before, both about citizenship status discrimination and national origin discrimination. For all those document issues, the unfair documentary practices, that was a prior training that's available on Switchboard, but of course we're still happy to answer those questions if you call our hotline. I have a colleague here who's going to try to answer some questions in the chat while I speak, but it's possible that she might not be able to. So you should definitely call the hotline if you have additional questions or if you asked a question that wasn't answered. So I'm, Rishan, if you can go into the next slide. Thank you. And then the next slide after that. So citizenship status discrimination is when an employer in the hiring or firing or recruitment process doesn't hire a worker because of their citizenship or immigration status. And so often this is when an employer says, oh, we only want to hire US citizens, or we only want to hire US citizens and permanent residents. That's typically illegal, and employers are not allowed to have that type of policy. There's some exceptions that I'll describe in a moment, but generally, you know, refugees, asylees, lawful permanent residents, US citizens, they're protected from citizenship status discrimination. And one thing to note, you'll hear today about employer size, and sometimes, you know, you go to the EEOC depending on the size of the employer, sometimes you go to IER, but for citizenship status discrimination, IER can take charges for any employer that has at least 4 employees. So it's all but the very smallest employers have to comply with this law. Next slide. So what are some exceptions to citizenship status discrimination? When can an employer take into account somebody's citizenship status when deciding whether to hire or fire them? Well, the first exception is if there's a law, regulation, executive order, or government contract that requires citizenship. or a particular citizenship. So for example, for all of us at the Department of Justice and our colleagues at the EEOC, we have to be US citizens or nationals to work for the federal government, and because there's an executive order that requires it. But the vast majority of jobs do not have that type of exception. And we have charges all the time where an employer thinks that they can only hire US citizens, but they're wrong. And so we've had cases against sheriff's offices, police departments, tech companies, people who have, or companies that have contracts with the federal government, because they thought they could only hire US citizens, but they were totally incorrect about that. And they were in fact allowed to hire a much broader range of people, including lawful permanent residents, refugees, and asylees. And so if you ever see a US citizen only hiring policy, you can call IER, and I'll describe the hotline at the end, but basically my office can call the company at that moment and ask them, you know, why is it that you have this citizenship policy? And then they can let us know whether it's a mistake or not. Of course, workers can also file a charge, which or you can file a charge, or your client's neighbor's best friend can file a charge. It doesn't matter. Anyone can file a charge of discrimination, and I'll discuss that at the end as well. So another group of people who are not protected from citizenship status discrimination are those who either lack work authorization or people who require sponsorship for their employment. But, you know, of course, refugees, asylees, and permanent residents, they don't require sponsorship, and so they are protected. And then the last thing I'll note is that the law that IER enforces is just one law, but there are other laws. And so we're happy to give you information about other possible protections as well. But, you know, we're not the only game in town. And so you might want to take that into account as well. Next slide. So here we have a poll question, and it asks whether your clients have ever reported facing discrimination based on any of the following. And so I'll give folks a few minutes, or a few moments, I should say, definitely not minutes, to answer the question. And you can certainly answer more than one box if it applies. Okay, that seems like probably enough time if you want to close the poll. And let's see what we have here. So English skills is you know, at 75%. That is unsurprising to me that so many people answered that. And I'm going to talk a little bit about it, but Maria is going to talk more about English skills at the end. But all of the issues that are on this slide can all be examples of national origin discrimination, which I will now discuss in a little bit more detail. So next slide. Great, thank you. So national origin discrimination, it's a little bit different than citizenship status discrimination in terms of which agency you go to, because both my office and the Equal Employment Opportunity Commission can investigate national origin discrimination depending on a couple factors. And the most important one is the size of the employer. So if there's an employer that has at least 4 employees, and it falls outside of the law that the EEOC enforces, which is called Title VII of the Civil Rights Act of 1964. So if it's not covered under Title VII and the employer has at least 4 employees, then IER would cover it. But the vast majority of employers fall under Title VII. And so for most national origin discrimination issues, you would want to go to the EEOC if your client wants to file a charge, because they will be the ones who would be investigating it. Next slide. So what is national origin discrimination? Maria is going to spend a lot of time about, you know, different specifics, but just to give you a groundwork, it's really broad. It's not just where you're from, but it's also your ancestry, your accent, whether you speak English, the way you dress, your name. These are all examples of national origin indicators, which means that employers are not allowed to take them into account when deciding whether to hire someone. And so, you know, for example, if an employer is requiring English fluency, that might be a type of discrimination. And so I'm not going to get too much into it now because Maria will be talking a lot about this at the end, but we just wanted to give you a flavor of the different types of discrimination that could fall under national origin, because it's not just what country are you from, but so much broader than that. And as you saw from the poll, it seems that a lot of clients, unfortunately, are facing this issue. Next slide. Okay, so imagine you're having a phone call with a prospective employer, and the employer says that they are not going to hire refugees because those folks are not native English speakers. Could this be a type of national origin discrimination? And so if you can, I'll give you a few moments to answer the question. I don't know that the poll has been set up yet. There we go. Since you only get 3 answers with this one, I'm just going to give it a couple more seconds and then we'll close the poll. Okay, great. All right, so let's see what folks said. So yeah, absolutely, it would be a type of national origin discrimination, and also, by the way, possible citizenship status discrimination as well, right? And the thing about national origin discrimination and English skills is native English skills are probably never something that you would be allowed to require for most jobs, because whether you're a native English speaker is different than whether you're a fluent or a proficient English speaker. And, for example, I'm not a native English speaker, but I feel like my English is, pretty strong. And so it would be a real problem for the vast majority of employers if they were to require native English skills. Okay, so next poll question. So imagine that you have a Syrian client, Amina, and she's not given a job. And when you call up to follow up why, the employer says that they prefer to hire somebody from the United States. Could this be national origin discrimination? Okay, let's close the poll. Absolutely. That can be national origin discrimination. And again, potentially citizenship status discrimination, depending on the specifics of the policy. And so as you'll see, national origin discrimination and citizenship status discrimination can be really intertwined. And you're not required to know which one it might be, because luckily, if my office gets a charge or if the EEOC gets a charge and it might relate to the other law, we'll refer it to the other agency. And so, you don't have to be a lawyer to know who to file a charge with, but, it's just also important for you to understand generally how these issues might arise. Okay, next question. So now imagine another client, Eduardo, has applied for a housekeeping job, and he meets the requirements, but he's not hired because his employer told him that he has an accent. Could this be a type of national origin discrimination? Okay, let's close that poll. So the vast majority of folks, you're correct, that can be an example of national origin discrimination. And, there's a few exceptions. Like, let's say instead of applying for a job as a housekeeper, Eduardo was applying for a job as a 911 operator, and imagine his accent was very, very thick. Maybe in that situation, the company that operates the 911 call center might be able to say, listen, your accent is too thick for everyone to be able to understand you in these emergency situations. But, as a housekeeper, these issues don't arise. And so absolutely, that would be just national origin discrimination. That wouldn't be a type of citizenship status discrimination. And, certainly, we would be concerned about that. Okay, next slide. So I discussed with you the different types of discrimination under the law that IER enforces, just those 2 areas. But how would you file a charge with our office? And so we'll go through that very quickly. So what happens is that you can file a charge, or like I said, not only can your client file a charge, but somebody can file a charge on your client's behalf. And we have charge forms in, I think, 16 different languages, including languages commonly spoken by refugees and asylees. And then if for some reason somebody doesn't want to file a charge, but my office is concerned about what happens, we can also open up an independent investigation. And then we'll investigate, and then we'll either dismiss the charge if we don't think that it violated the law. There's a lot of things that are unfair but not illegal, and so that might be something that happened. Or if we do think that there was discrimination, then we'll try to settle, and then if we can't settle, then we'll sue. Next slide. So there's a couple things that you should keep in mind in terms of filing a charge. Even if you don't have a charge form in the language that your client prefers, that's fine. You can just put the information, write it on a piece of paper or send it in an email, so long as the client is able to sign it, because they have to sign it. But charges must be filed within 180 days of the discrimination. And so even if your client isn't sure what to do, or they're scared, and these are all very legitimate concerns and issues, my office must receive the charge within 180 days. So you can file a charge online, by email or faxing or mailing it, but we're working remotely right now, so online and email is typically the best option. And then the link at the bottom explains, the link at the bottom is where you would go to file the charge. But you should always feel free to contact us, which brings us to the next part, which is our hotline. And when I was looking through the names, many of the people that I recognized because I've done hotline interventions for you. And so hopefully those of you that have had that type of experience with my office, either with me or with anyone else, you can put something in the chat. But basically, my office can help informally. So we're not talking about the investigations here, but rather through the phone calls, through emails, in an informal way. And this is not only with I-9 issues, which is something that we investigate, and that's something that I talked about at the other Switchboard presentation that's available on the platform for you to view the recording. And not only just citizenship status discrimination, like U.S. citizen only hiring policies, but also other things that might come up. Like, for example, if an employer is requiring a social security number from your client, and your client, new refugee just arrived, or maybe a new SIV, so that person's a permanent resident, and they don't have their social security number yet, especially because of COVID. My office can help with that. If a bank looks at your client's I-94 and says, what, this is a valid document? It's a piece of paper, no way. My office can call the bank and explain what the I-94 is and its purpose and what it reflects. So my office can help in a variety of situations with DMVs, certainly with E-Verify, with auto extensions. And so you should just call, because the worst that can happen is we tell you, sorry, we're not able to assist. But even things like unemployment benefits, my office can help with. And I did a presentation to some refugee service providers in Orlando, and this is a couple weeks ago. And I learned there that the Social Security Administration is not allowing new immigrants to get a social security number, but that actually goes against their policy. So my office contacted the headquarters of the Social Security Administration, headquarters contacted the local office, and now in Orlando, you should be able to get a social security number as a new, immigrant, and they should be giving you those appointments. And so that has nothing to do with employment, and my office wouldn't be able to investigate the Social Security Administration, but we can try to resolve issues informally that you might face every day. And so I really encourage you to call the hotline if you have any questions. There's no requirements that you do anything, and great, these are the hotline numbers. A little secret, both numbers go to the same receptionist, so don't worry if you call one number versus the other. And we're available from 9 in the morning to 5 in the evening, Eastern time, Monday through Friday. Calls can be anonymous. All of us attorneys and investigators, we're the ones who answer the hotline. And if you ask a question and we don't know the answer, we can research it and get back to you. So there shouldn't be any reason why you wouldn't want to call. You don't have to give us your information. And also it's very fast. It's 1 or 2 minutes typically to talk to us. So you won't have to wait on hold for a long time, because we are immediately available, since we don't have millions of people calling us. So we're typically able to answer these calls very quickly. Next slide. Okay, so now we want to hear from you. What are some of the barriers that might discourage immigrants and refugee workers from reporting discrimination? Fear of retaliation, yeah. And you know, it's such a good thing that you mentioned that, because under the law, both for IER and the EEOC, retaliation is illegal. So if an employer takes negative action against a worker because they called our office or they filed a charge, that is a separate violation. And one of the things that IER really tries to do with our hotline interventions is, you know, have an abundance of niceness, right? And also, we're not there. So we don't know what happened between your client and the employer. You might not even know for sure. Maybe you were there, but maybe not. And so we're not there to assign blame. We're very forward thinking, and we're customer service oriented. So we're just trying to fix the issue. And most of the time, the employers often just don't realize that they're wrong about the assumptions they're making, either about whether a document is valid or, you know, whether they're able to hire somebody of a particular status. And so as soon as we give them information that explains that they're incorrect, for them, that's often a great thing, because they're like, oh, great, now I get to hire this worker. So we do understand that retaliation can be a concern, but we try very, very hard, because we also know that you have relationships with these employers, that often they're repeat employers for you, and we don't want to do any damage to those types of relationships.
Okay, so we just want to give you guys a couple of pointers of how to talk to employers, because we do recognize that retaliation is a big fear for employees when filing claims. So we're going to share a little pointers with you. So you want to start by educating employers early in the relationship. When there's a question or a concern from an employer regarding the work authorization of your clients or other concerns related to employment rights, give them the benefit of the doubt. Assure employers that you are here to support them in the process and will work with them to find an answer to their questions until their concern is addressed. Also, don't be afraid to put employers in touch with the IER and EEOC.
And, you know, I see in the chat that some people are saying that often they just don't have context for what might be correct or incorrect. And IER has a specific flyer in, I think, 15 different languages commonly spoken by refugees and asylees as to what to expect in the employment process. And I believe that link is at the end of the presentation. I think it might only be in English, but we have, the link is only in English, but we have a lot of other materials. And so you should certainly feel free to ask me if you would like, or to look on the website, call the hotline to ask about it. But we do have some materials so that workers get a sense of what their rights are. And there's 2 flyers in particular geared to refugees and asylees in many different languages. So next slide. Okay. So imagine that you're speaking with an employer about, you know, national origin discrimination, and the employer just doesn't know. You know, what is something that you might decide to say to them to help educate them? And this is for the chat, I believe.
Yes, please type your answers in the chat.
Yeah, absolutely. People can refer employers to our resources, and often there's different levels of engagement. So step 1 might be to say, hi, employer, here's a flyer from the Department of Justice that, you know, if you see in the 3rd paragraph, it mentions that, and so you wouldn't even need to involve us. Maybe you called us and we pointed you to that flyer and we told you, hey, look at the 3rd line in the 4th paragraph. That's the thing that, you know, your employer might not understand. But they don't need to know that you ever contacted the Department of Justice. Or maybe after that doesn't work, then you decide, okay, well, maybe a friendly, you know, Department of Justice employee might be able to make a phone call. You know, there's a lot of different options that are available to you, and you get to decide. IER never makes these decisions. They're always yours. But, you know, they range really from, you just trying to talk to the employer, giving them resources, but also filing a charge. And, you know, certainly anything along that range is whatever you get to decide, whatever you prefer. And so hopefully, you know, through the options that you have, you'll be able to get your client back on the job. So for these last 3 slides, I'm not going to go over them because they are basically for your benefit if you want to look at them later and you're trying to think, is it IER or the EEOC that I go to? And so if you go to the next slide, you'll see, oh, sorry. Before that, actually, there's a poll. How confident are you in knowing the difference between the EEOC and IER? It's okay if you're also not super confident, given that Maria hasn't spoken yet, so you might not know, apart from national origin, all the other areas that the EEOC covers, which they cover many. So, you know, some of you might already have a lot of experience with the EEOC, and so you might be very confident about what the differences are. Okay. Yes, if you close the poll. Okay, so it seems like this might be a good webinar for folks if you're not super familiar with the differences. And again, that's totally fine. I didn't actually, I knew about the EEOC before, when I was an attorney, before I started working at IER. I had no idea IER existed before I saw the job announcement 10 years ago. So I'm with you on this, that, you know, sometimes the information is not always super obvious. Next slide. Okay, so you'll see why I'm not going to go through these slides. It's just really listing a lot of information. But because the IER hotline you can get through so quickly, you should always feel free to just call and ask if you have any questions, if you don't know who to go to. And even if something is under the jurisdiction of the EEOC, like let's say it's a large employer, IER can still do a hotline intervention if it's about a national origin issue or a citizenship status issue, or, you know, and a whole bunch of other issues. But even though national origin for large employers, it falls under the EEOC, IER might still be able to do a hotline intervention. Okay, so now I'll turn it over to Maria for her great presentation.
Rishan, are you going to be reading the questions for me? I'm not able to read them.
I'm sure, I'm happy to do it. So Maria, which employers, employees, and protected categories are covered under the laws that the EEOC enforces?
All right, thank you very much. Well, the EEOC enforces a number of federal laws prohibiting employment discrimination. They go all the way back to what I call the grandfather law, Title VII of the Civil Rights Act of 1964. And these different laws make it clear that employers are not allowed to engage in employment discrimination. These employers can include private employers. It could be a small mom and pop restaurant in your neighborhood, and maybe they employ 25 people. It could be very large employers that employ hundreds or thousands of workers. We also cover educational institutions, labor organizations or unions, as well as joint labor management, apprenticeship, and training committees. Employment agencies or staffing agencies are also prohibited from engaging in employment discrimination, as well as state and local governments, be it city, county, or state level. So let's say, for example, I apply for a job here in Wisconsin with the state of Wisconsin, or with Milwaukee County, or the city of Milwaukee, and I feel I'm not hired because I'm age 50 years old. I could bring a charge of discrimination with the EEOC and bring that against the city, the county, or the state. And generally speaking, in order for us to have jurisdiction or authority over these discrimination complaints against employers, generally speaking, we need 15 or more employees. As for the individuals who are protected under these laws that prohibit employment discrimination, this can include the current employee. It may be an ex-employee, a former employee, someone who no longer works with the employer, but they have come to the EEOC and they have filed a charge within the right amount of time and met other jurisdictional requirements. Protections are also afforded to the temporary employee, that would be the person working through the temporary staffing agency. The job applicant is also protected from employment discrimination. So something might go wrong during the hiring process that may be employment discrimination. Those individuals, again, are also protected by those EEO laws. And we also cover non-US citizens regardless of their immigration status. So though, generally speaking, then those are the employers that are covered and the workers that are covered. Now, when it comes to our protected bases, it is illegal to treat people differently in any aspect of employment because of certain personal characteristics that are covered under the federal laws enforced by the EEOC. Therefore, no discrimination in any aspect of employment because of race, color, religion, national origin, age, that's 40 and older, disability, be it physical or mental. We also cover sex discrimination. So sex would also include pregnancy and LGBT individuals, lesbian, gay, bisexual, and or transgender individuals. We also cover genetic information, which is also illegal discrimination for the EEOC. So generally speaking, those are the protected categories covered by EEOC. And as I tell people, don't think of these protected categories as a little checkbox on your driver's license or on a census form, as we may often take a broad view as to what those protected categories may mean. Take race, for example. There is no specific definition as to what race means under Title VII of the Civil Rights Act of 1964. And if you were to combine that in with color and national origin, we could be talking about anything from complexion or skin tone, facial features, hair, ethnicity, or country of origin, for example. Sometimes you may also see within group discrimination. So take, for example, the category of persons 40 years of age and older. A company may be going through a layoff and they may decide they really don't want those older workers to be working for them. And so they lay off the much older workers, 55 and older, at a disproportionate rate than the workers who are in their 40s. So in this case, we have a subset of those workers, 55 and older, who are being treated through worse discrimination because of that protected category, again, within group. And we also have association discrimination claims. So for example, let's say that I apply for a job with a company and somehow I mentioned that my husband has multiple sclerosis, MS, and they decide not to hire me because they're thinking, wow, if we hire Maria, she's going to take off work all the time to take care of that husband with MS. Or she's not going to be able to travel a lot because of that husband with MS. Or she's going to drive up our insurance costs because she has a husband with MS, and they don't hire me. I could bring a discrimination complaint under the Americans with Disabilities Act, not because I have the disability, but because of my relationship with someone who does. In this case, my fictitious husband who has multiple sclerosis. And there are also some other categories of protection that fall under these bigger umbrellas that you don't see necessarily spelled out under the specific statutes. So for example, there is protection with regards to caregivers, and they may cause discrimination, let's say, based on sex or based on disability. We also have protection for victims of domestic violence, sexual assault, and stalking. They may come under the bigger umbrella of sex discrimination or disability discrimination. Sometimes individuals may find that they can't get hired or promoted because they may have a criminal record involving arrest and or convictions. And again, not specifically spelled out in the laws enforced by the EEOC, but if the employer were to use that information in a negative way that could cause discrimination, then we might see, for example, coverage under race discrimination, sex discrimination, or national origin discrimination. So that's a quick summary then about who the employers are, who the individuals are protected underneath the laws enforced by EEOC, as well as the protected categories. Next question, please.
How does national origin discrimination intersect with race and religion?
Okay, thank you very much. Well, Lisa had done a really good job about laying out about national origin discrimination. So I'll just provide a quick summary about that. So at the EEOC, when we're looking at national origin discrimination, it could mean, for example, this different or negative treatment because of the individual's or their ancestors' place of origin. It could also be discrimination because the person may have certain characteristics related to a particular national origin group. Characteristics that may be physical, cultural, or language characteristics. Again, there could also be discrimination because of association with people of a national origin group. So a summary, that would be about national origin discrimination. And sometimes we do see that intersectional discrimination, where these different categories can come together and unfortunately make a bad cocktail for discrimination. So for example, you may see individuals who may be Muslim, for example. So their place of origin or their ancestors may be from the Middle East, but their religion is Muslim. And then you may see discrimination because of that intersection. That maybe the employer doesn't want to hire these individuals because they are Muslim and or Middle Easterners, or maybe the employer may forget or not know about their responsibilities to provide religious accommodation. So employers need to provide religious accommodation when a person's religious beliefs conflict with their work obligations. And employers then are required to provide, again, this religious accommodation unless they are able to show more than a de minimis or administrative cost, or let's say an extreme disruption to business operations, or some other significant financial cost. But often employers, they're really not thinking this through, and they need to do what people always need to do when they're asking about an accommodation at work, which is to have a conversation. And often there could be some easy accommodations that could be provided, such as a flexible schedule, for example. Maybe someone is a Muslim and they need to pray 5 times a day. And it may be that 3 times during the day, that is during their work hours. They may be able to work with the employer, maybe have some extended breaks to be able to do their prayer, but then, make up that time, let's say at the beginning of the day or at the end of the day. That would be an example of a religious accommodation. So again, that would be an example of the intersection between race and religion and national origin. Next question, please.
What are some language discrimination issues based on accent, English-only policies, and English language fluencies?
My favorite topic, talking about language issues. Background information, when I came aboard at the EEOC way back in the day, 1991, started when I was 10, total violation of labor laws involving children. I came aboard as the first bilingual Spanish-speaking investigator in the Milwaukee district office. So I dealt a lot with these language issues. And so we see different sides of the same coin. Let's look, for example, about accent discrimination. And if I could be candid for a moment, often people see accents, all right? They see accents because of that person's appearance. And when you add in other things like, unconscious bias or preferences, then sometimes individuals in the workplace may not be as forgiving as to a person's accent, unless it's one of those accents that they find more favorable or pleasing. So for a moment there, permission to put on stereotype caps on, here in the United States, maybe people have a more favorable perception of people who may have an accent that is Italian or French, or heck, everything now is Downtown Abbey, so a British accent, for example. But when it comes to those other accents, people tend to see more with their eyes as opposed to their ears. Now, certainly, employers may be able to make certain distinctions when they're making employment decisions based on accent. But if an employer is going to be looking at accent as the basis for some type of employment action, then the employer really needs to look at 2 different things. One, they need to ask themselves whether or not it is important or critical for the person to speak an unaccented English. And then they need to follow that up with the second question. Does that person's accent interfere with their ability to communicate? So again, number 1, employers need to ask themselves, number 1, does the ability to communicate, in fact, material relate to the ability to perform that job with a minimum accent? And number two, does that person's accent actually interfere with their ability to communicate? And again, this could often depend on what the position is. So the employer can't take a broad view as to, well, we're not going to hire anyone with an accent because, as Lisa had pointed out before, well, it depends on the type of position. So maybe a person is working at a police department and they are doing janitorial duties. The accent probably is not going to be much of an issue as they carry out their job functions of a janitor, but different, like Lisa had pointed out, the dispatcher, the one who's taking the calls in from people calling 911, that may be situations where we need to be careful that a person's accent doesn't interfere with that ability to communicate critical information. Then we get to the topic about English fluency. And again, same thing with an accent. We need to see whether or not that person's English proficiency interferes with job performance. Now, it may happen in certain circumstances that you do need someone to speak a certain level of English proficiently. But again, going to depend on the position. Let's take a restaurant scenario, for example. So the person who may be the dishwasher or maybe the cook or the person that is bussing tables, maybe even the wait staff, they might not speak English fluently, but it's enough for them to do their job. Case in point, here's an example. I travel a lot in my job. I don't remember which airport I was at. They all change, but there's always a McDonald's. So I go to McDonald's to order something, and they had some individuals who were LEP, limited English proficient. So their English wasn't the same level as mine, but you know, they're just taking food orders, don't need to speak a lot. And in fact, they had pictures laminated on the countertop at this McDonald's in the airport where people could also point to the food that they wanted. All right, not a lot of English necessary for that type of position. Now, that would be different, let's say, as to the manager of a restaurant who may need to place orders in English to get certain products, or maybe they need to fill out certain forms, or they need to prepare certain reports, or certain tax information, whatever it may be. That may be a person who needs a higher level of English in order to do the job. So again, English fluency. Let me talk about one of the other things that I heard about often as a bilingual investigator, which is still an ongoing issue, is English only policies in the workplace. Now, EEOC does permit, or the law does permit employers to adopt English only policies under certain circumstances. And again, you know, we need to look at, you know, what are the reasons? Or as EEOC often likes to say, is it job related and consistent with business necessity reasons? So the employer again needs to justify an English only rule for business necessity reasons. It may be, for example, communication between supervisors and managers. If they're not understanding each other, obviously that job can't be done or that service can't be delivered. It may be communication in English because there may be some dangerous situations, let's say on a construction job, and we want to make sure that everyone understands safety protocol and they understand instructions to make sure that everyone is safe. So again, employers need to make sure, what is my business justification reason here? One business justification reason that does not support anything is because I think other people are talking about me, which is usually the type of things that I would hear from employers or what I would hear from the workers making those types of complaints. So usually the scenario is someone is speaking another language, you know, fill in the blank. They're speaking Spanish, they're speaking Hmong, they're speaking Navajo, others speaking Russian, whatever it may be. And then what happens is other people hear that and they assume what? They're talking about them because they're so interesting that there could be nothing else that they could be talking about. When in fact, they're probably talking about the same thing that everyone talks about at work. You know, what are we going to have for dinner? Who's going to pick up the kids? Am I going to be able to pay for that car repair that I need, et cetera, et cetera. So again, getting back to the English only rules, does the employer have a business necessity reason? We're also going to analyze when is the employer going to apply this English only policy. Now, if it is at all times, that pretty much is going to violate the laws enforced by EEOC, because they're not able to show business necessity reason that you must speak English in the break room, at break time, at lunchtime, in the parking lot, which was one case that I had where the employer came out and told some workers that they needed to speak English, and even in the parking lot, they needed to speak English, all right? So why would that make it difficult then for a person who is LEP, limited English proficient, and for them to most likely break an unjustified or non-business reason to speak English at all time? That would be because of code switching. So this is this unconscious habit for individuals who are bilingual, or in this case, limited English proficient, to revert back to their primary language. And it's difficult for them to completely suppress their primary language. And so, of course, they're more likely to break an illegal English only rule that's not supported for business reasons. This even happens to myself. It happened to me last Friday. So I'm someone who considers myself bilingual. I was on a conference call with other people. We were talking about translations and the importance and dialects. And I could not think of the word in English for dialect. And I said it in Spanish, and I struggled around for, about 30 seconds there until someone stepped in. They said, "You mean dialects?" I go, "Yes, thank you, dialects." So that's why. So again, we need to justify that. What's the business reason? When is it going to be implied? All right. Now, if an employer does have an English only policy in the workplace, and maybe they can support that, this cooperative work assignments, ensuring a supervisor can communicate with subordinate employees, working with English speaking customers, for example, then we also need to make sure, has the employer notified the employees of this speak English only rule? And often that's the part there where in many of, well, actually, I would say all of my speak only English only cases, that there are violations. That if this rule is so important, why was it not put in writing and communicated to the employees? 99.99% of the cases I had involving speak English only policies was because of that knee-jerk reaction. Someone complains to HR, to a supervisor, that people are speaking another language. Then they come down, they say, "You have to speak English here at our place of business." And that's when the rule is instituted. So there's none of that analysis, let alone putting it in writing. So if an employer is going to have a speak English only rule to protect themselves, to guard against discrimination case, put it in writing. State when people need to speak English. Let the employees know when they do not have to speak English, therefore speak in any other language, and what the consequences are for violating the speak English only policy. So that was a quick little snapshot about the language issues that we see at EEOC with respect to accent, English proficiency, and speak English only rules. And next question, please.
Okay, we're going to launch a poll. What do you think is the most common type of workplace discrimination? And your choices are race, retaliation, sex, disability, or unsure.
And the poll results are, we have race at 50%, retaliation 10%, sex at 18%, disability at 16%, and 6% unsure. Well, unfortunately, retaliation has been the #1 protected category upon which people have filed charges with the EEOC, retaliation. And retaliation is prohibited under all of the laws enforced by EEOC. When EEOC first opened their doors in 1965 till about 2010, I believe, race was the #1 protected category upon which people filed their charges. So for about a good decade now, retaliation has been at the top, #1. The #1 most frequently cited protected basis on charges filed by the EEOC. Again, retaliation prohibited under all of the laws enforced by EEOC. It is unlawful to penalize, punish, or deny an employment benefit because a person has opposed what they believe to be unlawful employment discrimination. So opposition could be very informal. It could be griping to your supervisor. You know, I'm the oldest employee working on this shift. I've been here for 1 year. You just hired these 2 kids in their 20s. And after 3 months, they're already earning $1 more per hour than I am. That's bogus. What's up with that? I think it's because I'm an older person. That is opposing employment discrimination. That's opposition. It could also be maybe going down to the Human Resources Department and making a complaint, or contacting corporate headquarters and making a complaint, or even filing a union grievance. And in the union grievance, the person contends that they have been a victim of employment discrimination. It could also be participating in EEOC's process, that you have formally filed a charge with the EEOC. Or maybe you were a witness while we were conducting an investigation and you provided information as a witness to the EEOC. Or maybe if a case goes all the way to the point where we actually litigate and file a lawsuit in federal district court, you may have a person on the stand who gives testimony during that lawsuit about employment discrimination. So participating in our process is also coverage for individuals. It could also be that people are retaliated against because they have requested or asserted the rights to reasonable accommodation because of disability or because of religion. Now, retaliation doesn't always happen, but sometimes it does, that the employer becomes upset with that person because of their informal opposition, because they did participate in the EEOC's process, or they asked for an accommodation. So you may see things like excessive discipline or going out of the progressive discipline policy. People might be harassed. We're working first shift for 10 years, boom, you're suddenly bumped to third shift. The promotion, the raise that was automatic and you should have got, poof, it disappears. These might be examples of retaliation. And we encourage individuals that if that happens to you, to immediately contact us, because we do take retaliation to be very seriously. And what is our next question, please?
Last question. What is illegal workplace harassment?
Oh, that is a big one. I need like 2 hours just to talk about harassment in the workplace, which is unfortunately an ongoing issue that we see nationwide in the United States in every imaginable workforce, whether it's blue collar or white collar, from the small company to huge corporations, harassment. So I'm just going to give you that little snapshot window to give you a flavor as to what harassment would mean. So one type of harassment is the tangible job action harassment, formerly known as the quid pro quo harassment or the this for that harassment. And this involves a supervisor or manager who, frankly speaking, is abusing their power. And what happens in this situation is that an employer, an applicant, refuses to submit to a supervisor's sexual advance. And because of that, it can result in a negative, tangible employment action. Tangible employment, I say like touchable benefits, for example. So let's say a hypothetical that a person's applying for a job. You have this election official who is a supervisor manager, and they expect the person to submit to their sexual advances, to do a sex act, for example. So it's conditioned that if you want to get hired, you need to do a sex act. Or if they tell the employee, you need to engage in a sex act if you don't want to get fired, or if you want to get a promotion, or you want to get that raise. And if that person refuses to do so, then that person takes that negative action. That means that if the applicant doesn't submit, they don't get hired. Or if the employee doesn't submit, they don't get that promotion, they don't get that raise, or they get fired. And one instance of this would be enough to establish a violation in terms of harassment, tangible job action harassment. Now, the bigger catch-all category for harassment is our hostile work environment harassment. This is unwelcome, racial, ethnic-based, sex-based, disability, ageist remarks, etc., based on a protected category that either unreasonably interferes with that employee's ability to do their work, or it causes an overall intimidating, hostile, or offensive atmosphere. So in terms of race, color, national origin discrimination, it could be jokes or graffiti or epithets, maligning that person's ancestry or race or where they come from. It could be negative comments about their physical features or cultural or language characteristics, or even dress. Comments that just show animosity, that can also ridicule that person's background or heritage. So that would be an example of the race, color, and national origin. When it comes to the sexual harassment, then it could be demands for sexual favors, unwelcome phone calls, texts, emails, or social media. We also have the accidental touching of individuals, that's accidental with air quotes, pressuring people out on dates, for example. It could be sexist graffiti or jokes or innuendo or cartoons. Unfortunately, we also have serious cases that actually involve physical contact, physical assault of a sexual nature. I've been privy to cases involving, let's say, immigrant farm worker women who were raped at knife point by their supervisor. And that would be an example of sexual harassment that we see. When we're looking at harassment in the workplace, and let's say focusing right here on talking about refugees and immigrants, for example, often these individuals, if they don't hold higher degrees, may be working more in blue collar type jobs. And so you see these people being more victims of harassment and overall discrimination due to their national origin in industries such as agriculture or food and meat processing and hotel and restaurant industries. Again, just a very brief snapshot about harassment, to make sure that people understand that it is illegal and that people need to be sure to hopefully reach out to someone at their place of business to put their employer on notice. If you're not safe in making that complaint with the supervisor or manager, certainly there are other avenues, hopefully like going to human resources or corporate headquarters. And once an employer is notified about harassment, they need to step in. They need to take prompt, effective remedial action. Put a stop to the harassment, investigate, and make sure that the harassment doesn't happen again. Sometimes people are afraid to voice a complaint about harassment, but sometimes the harassment is so pervasive, it's so out there that everyone knows about it. And when it's out there in the open, then the employer has been put on notice, and even in the absence of a formal complaint, they have a responsibility to step in and to stop it. And what is our next question, please?
That was the last question, but we are going to open up a question and answer period. So if you have a question, please put it in the chats. Liza, we have a question for you. We know there are delays in the Social Security Administration accepting and processing applications for Social Security numbers. Although Social Security numbers are not required for employment, can you provide any suggestions for communicating with the Social Security Administration about these cases?
Yeah, absolutely. So because of COVID, Social Security Administration offices are closed except for what are called dire need appointments. And getting a Social Security number for somebody who is 12 years old or older is considered dire need. And if the person is under 12 but needs benefits, that is also considered dire need. And so any office that is not giving these appointments is going against Social Security policy. And if you've already tried talking to the Social Security Administration, or maybe you're not able to get through, that's fine. Just contact my office. It's very easy for us. We let headquarters know, headquarters contacts the local office, and then that's it. we don't even identify who it was who told us. We just say, hey, Social Security, we hear that there's a problem in X location. What we need is a street address, and then we're able to help. But certainly, you know, employers shouldn't be requiring Social Security numbers, and although your clients should be, you know, requesting them, you know, the Social Security Administration should be allowing your clients to be able to make these appointments.
Thank you. The next question is for you both. How do workers know if discrimination has occurred, and what if they don't have proof?
Is that okay if I step in, Lisa? I'm going to go ahead and answer that question. One thing is, depending on the type of complaint that the worker has, they may or may not be aware of what we call comparative information. A job applicant, for example, someone applies for a job, they feel they're qualified, they don't get hired. They obviously wouldn't know what the resumes or the application forms look like for the other candidates, let alone the person who was hired. And that type of situation, of course, they would have no knowledge of it. But that's not to say that the person cannot be observant of what's going on during the hiring process. So for example, let's say that a person is going in person pre-pandemic to apply for a job, to have their eyes open as to what the racial composition is of the workforce. Do they see, let's say, that maybe persons of color who are maybe not the faces they're seeing around them, that may be a way that they see something going on there. Or maybe there may have been a remark made during the hiring process that may indicate some type of bias with respect to their protected category, race, color, sex, or whatever. For people who work for an employer, they may already be aware of who the other people are who are being treated more favorably than themselves in the same situation. So if I'm working at a company and I come in late and I immediately suspended, and I think it's because I am Hispanic, Mexican American, I know some of the other people who have come in late, and maybe they don't tell me their business all the time, but I kind of know everyone. And I know that people who are not Mexican American or Hispanic have not been suspended. Maybe they get a verbal warning. So you might already have some of that comparative information. Now, when a person comes to file a charge with the EEOC, they will be interviewed by an investigator. And we don't expect you to pull up with a U-Haul truck of all kinds of documents, because the EEOC does have at its disposal certain investigative tools. So for example, we are actually able to ask the employer a lot of questions in writing and for them to respond in writing. We can also request certain documents. We are also able to do an on-site investigation, go on-site to the premises to collect that information. When employers refuse to provide that information, sometimes we may actually go to subpoena enforcement. So we have these avenues to collect that information. And just something for people, as they go through the interview with an investigator, to not be offended when the investigator is asking lots of questions. And that's because the worker has so much information locked in their head. And of course, they're upset by the situation. It's the investigator's role then to ask these very probing questions to elicit the information they need to understand what the case is about. And so they know in what direction they need to go and what information to collect. So when a person comes to the EEOC, they just need to meet jurisdictional requirements. Generally speaking, more than 15 employees working for that employer, that they have filed a charge with the EEOC either between 180 days or 300 days. And this can vary from state to state. The sooner the better, of course. And the person needs to profess a belief that they have been treated differently because of their protected category.
Okay.
Yeah, and I totally agree with Maria. And one just thing that I would add is I think all of that means that the worker doesn't need to have proof. The worker never needs to have proof. And that's what the investigation is for. And so that's why Maria was describing all these techniques, because often the worker will have nothing, and that's fine. They can just file the charge explaining why they think it might have been based on whatever protected reason, but they don't have to have an email or a video or anything like that, because that is what our investigation is for.
I'm going to add in a little bit more here about the types of charges the EEOC has, because often sometimes people may be fearful to file that charge in their own name for whatever reason. So for example, the laws that we protect also protect undocumented workers from employment discrimination. So we have different types of charges that come before the EEOC. One is the person filing a charge in their own name. Maria Flores bringing a charge that I was suspended because of my national origin, Hispanic. But we also have class action charges. So maybe I might say, well, you know what? I'm aware that other Latinos in my place of business have also been subjected to much harsher discipline for attendance infractions than people who are not Hispanic. And so I might bring that allegation in my charge to cover all of the other Hispanic workers at my place of business. We also take third party charges. So there may be an individual or an organization that represents the interest of the complainant and or a group of workers. So in the high profile case I work with undocumented Hispanic women who were victims of sexual assault, including rape, it was a women's domestic violence shelter that filed a charge on behalf of these workers. So it was the Iowa Coalition Against Sexual Assault, I don't remember the name at this point, versus, ABC Company. Well, actually, we filed a lawsuit to Coster Farm, so I can name the employer, that's public record. Or in another case that I had, which was also high profile, again, in the news, public record, this involved a Holiday Inn Express, and we had a union that filed a charge on behalf of the workers. So it was union local, ABC versus Holiday Inn Express on behalf of Hispanic janitors who were victims of employment discrimination. The EEOC also does have commissioner charges. And I used to work in our systemic unit, and often those were the types of cases that would be a commissioner charge. So we would do preliminary work within the agency. So in my office, Milwaukee District at that time, we would alert headquarters about our preliminary findings and state our reasons as to why we need to investigate. If they concur, then you would have EEOC Commissioner Silverman versus ABC Company. So you don't actually have a person that has filed a charge. And we can also do directed investigations, for example, under the Age Act, where we don't even need a charge at all. It would be a letter that we send to the employer stating, we're going to be conducting an investigation of potential violations under the Age Discrimination and Employment Act. So as you can see, there's a variety of ways that a charge can come before the commission. Thank you.
Okay, we have one more that keeps, we have two more questions, but one that keeps popping up. Is there a service fee for IER or EOC if a person wants to file a claim?
No, everything is free. Your tax dollars at work because we're government employees, and so everything is free. There is no service fee, no charge for any part of our investigations at all, or even in hotline interventions. And if anybody says otherwise, then it's a scam. They're not actually from the government.
I'm going to ditto that. I'm also going to say no attorneys necessary. There is no fee to file a charge with the EEOC. The same with IER. We're also accessible to people in different languages. So if an interpreter is needed, whether language or sign language interpretation, we also provide those services. So also to be careful of the scams. I can only speak for myself and the Hispanic community. Sometimes there are individuals there who claim that they can work on your behalf for a fee. Again, you don't need a middleman to file a charge with the EEOC, someone who says you need to pay them to do it for you. Yeah, persons can just file directly with the EEOC free of charge, no attorney necessary.
Okay, we have one more question. It's a scenario. Can an employee be fired because he or she walks out of the production line to go pray? He or she is given a chance to pray during the break times, but refuses that his time varies and takes extra breaks.
I am thinking on that because EEOC does not take a cookie cutter approach to everything. And so for myself, if it's based on a real case, I would need more information. Certainly the person has that right to articulate to the employer that they need a religious accommodation. Then the employer should have a discussion with that individual about that. Now, as for walking out without permission, This is not the EEOC talking. I'm just going to repeat what I often hear from other labor and employment attorneys that I usually agree with, especially union representatives who will say, unless your life is in jeopardy, follow the employer's rules and regulations and then come back and make the complaint so that you don't get fired for walking off the job, for example. But as to how many breaks can be provided is going to depend on the type of business, the position that the employee holds, and the impact that is going to have on the job being performed. So again, case by case basis, very difficult for me to answer that question at this particular moment. I do apologize.
Lisa, do you want to follow?
Well, because that would be a situation of religious discrimination, that would fall squarely under the EEOC policy because, you know, as Maria mentioned, reasonable accommodations, you really have to look at the whole picture for everyone. And so that wouldn't be something that IER would get involved in because we're just those citizenship status and national origin unfair documentary practices bubble.
Thank you. Okay, so we have some recommended resources for everyone. As I stated in the beginning of the webinar, you will receive this the slide of today's webinar. So I hope that everyone was able to list types of discriminations that are covered by the law. I hope you were able to identify workplace discrimination. I hope you were able to describe how a client can file a charge if they feel they have been discriminated against. And I hope that you're able to describe the difference between the Equal Opportunity Employment Commission, the EEOC, and the U.S. Department of Justice of Civil Rights Division, Immigrant and Employee Rights Section, IER. If you haven't been to our website, please go to our website and check it out. There is a part 1 to this training that is on our website. I encourage you to sign up to our newsletter so you can find out what we're doing in the future. And after you will receive, we'll put in the chat a survey that we ask you to complete. We want to know what you thought about it. And if you have any additional questions, please reach out to us. And thank you for joining us today.
Thank you, everyone.
Thank you so much.
Bye-bye.